Thank you very much for inviting me. It's great to be here again. I was telling Felicity that this is pretty much the only good thing about Brexit is that I got to visit Cambridge twice this year. I cannot find any other positive in it. So I was here in October also discussing citizens' rights, so I didn't know whether I had more or less the same audience. And for this reason, I concentrated more on what might happen if we do not reach a deal or if we change the withdrawal agreement. I don't think even if the withdrawal agreement were to be changed, I think if there is a deal, the citizens' part will remain as it is. I don't think the European Parliament would allow it to be changed. And I don't think there would be political interest on either side to reopen that. So by means of introduction, just to remind you what is in the withdrawal agreement is the aim is to for Brexit to be the least destructive possible for EU citizens in the UK and UK citizens in the EU. And pretty much the aim is to allow this status, to grant a special status to EU citizens and UK citizens, or what I call Brexit citizens after Brexit, that will last for their lifetime and gives rights that are similar, although not equivalent to what they have currently. So the idea is that Brexit citizens would be entitled to work and live where they reside, and something possibly the most important bit of the withdrawal agreement for citizens is that the evidence needed will be much lighter than it might be otherwise. So the way out to prove that you were in the country, that you were working there, that you were lawfully resident. The withdrawal agreement anyway is in any case problematic because it leaves a number of categories very vulnerable, especially children, disabled people, and it has a greater impact on women than it has on men, probably. But the withdrawal agreement still guarantees the life and the continuity of rights of citizens, and it comes in, in a package that should see also social security coordination continue beyond Brexit. Now, the main problems, we always had those, but the main problems that will have to be addressed in case of no deal, and that were partially addressed in the withdrawal agreement, is what happens, to all of this. So you have you start from residency rights, who can stay in the country where they are, working rights, who can work, and crucially, as John has already mentioned, the problem of self-employed people, who will be, if we don't have a deal, will be quite dramatic, I think. Then you have obviously to decide who can access the welfare, what you do with vulnerable citizens. So those citizens who might have come in and out of work, who might be homeless, who might be not well, who might be disabled, who might have mental health problems, who might have more difficulty in establishing residencies. What do you do with your pensions and social security coordination? We have a problem of the pensioners abroad, even though Spain has indicated that they are going to allow them to stay even with comprehensive health insurance. But as in European law, the pensioners can now reside in another European country because their health insurance is provided by the country where they last worked. Obviously, for pensioners, health insurance is incredibly expensive because it's an age-related risk. And if they don't have the health insurance cover, they would not be able to stay in the country of residence. Spain, that is the biggest importer of, if you can say that, importer of British pensioners, has indicated that whatever happens, they will be happy for those pensioners to keep on residing there even without health insurance. But this is an ad hoc by Spain concession. There is a big problem if we don't have a deal with recognition of qualifications, including for those of you who are EU non-British in this room, because you might have started a degree in the expectation that your degree would be recognized at a later stage, and that might not be the case. And there is a big problem for service provision and cross-border work, because again, there you need a bit of coordination. So the two options at the moment in this rather volatile political situation is that we might have no agreement. I hope this will not happen, but it's still the default legal option. Or we will have a withdrawal agreement, and then who knows what will come with that. Now, if we have no agreement, you have three possibilities in relation, two possibilities and one. That would be the situation in the UK. So in the situation in the UK, as John has very eloquently and entertainingly said, is that the EU citizens in the UK would acquire some sort of special alien status. So, friendly aliens. But it's not that it's going to be particularly nice for them. Let's not, as John has indicated. In the EU, there are two possibilities as far as I'm concerned, because one is my fanciful interpretation of Directive 2004/38. So for me, the UK citizens in the EU need to have a special EU status, that of former EU citizens, because for me, maybe it's just me being very emotional, but if union citizenship does mean something, then I cannot accept that the 1,200,000 citizens in the EU might, from one day to the other, be treated as if they were third country nationals. So I simply cannot, there must be a way to avoid that. Conceptually, for me, it's very difficult to accept, because if we accept that you can become from an EU citizen who has exercised a right in good faith and lawfully granted by the treaty from one day to the other, you can become a third country national, then I think citizenship really doesn't mean anything. But the Commission's view is that those citizens, British citizens in the EU, will become on the 30th of March, they will wake up and become third country nationals. That's not a good situation for them. So for me, as I said, that is not a very attractive proposal, the idea that citizens just, lose everything from one day to the other. And also because conceptually for me it's very difficult to tally that with EU citizens. And so what I've tried to do, this was for a report I wrote for the European Parliament, what I tried to do was to look at Directive 2004/38 to see whether it could be of any help. And I do accept that my interpretation is really wishful thinking. I think we might, because there are lots of citizens' organizations that are already preparing their legal battles post-Brexit, we might see if we can try it. But the route I chose was to go by an analogical interpretation, and of course Directive 2004/38 does not provide for former citizens. And so for me, the closest I could get was to third country national spouses who are no longer spouses of EU nationals, who under Directive 2004/38 do not lose the right as long as they have been married for a certain time. So this is how I got there, but I don't think it's particularly important now. But what I would like to highlight is how important it is to try and find a framework if we don't have an agreement, so as to properly protect at least British citizens in the EU, since it is not for us to protect EU citizens in the UK. As I said, the Commission has indicated that they believe that UK nationals will become third country nationals, and has urged the Member States to be generous in the way they will treat. But what does it mean to be generous in this case? Because there are unfortunately also legal limits. But here is a table detailing a very short table detailing what the difference would be if we manage to grant the UK citizens a special status vis-à-vis what they get if they are considered third country nationals. And if they have a special status that would derive by an extensive interpretation of Directive 2004/38 and a very imaginative interpretation of the citizenship provision in the treaty, they would continue to have a right to reside, work, and be self-employed in the country where they are. They wouldn't be allowed to move in another country to work in another country. Crucially, they would be entitled to equal treatment in respect to all matters, including access to welfare provision, and they would be able to mature the right to permanent residency within the scope of Directive 2004/38. Also, crucially, as far as I'm concerned, really crucially, they would be protected by EU law. The National Court would be able to make preliminary rulings, the Charter would apply, the principle of proportionality would apply, and so would an extensive interpretation, and they would have the same protection across the 27 member states. Now, this is very important because some member states, including, to my surprise, Italy, and not because I thought they weren't going to do it, but I just thought that they were not organized enough to actually issue a communication in this respect, but they were, amazingly, in January. But some member states have indicated that they are going to recognize the residency rights of British citizens who are in their country at point of Brexit. Some member states have not, and I'm told by the representation of the British citizens in Europe, one member state has no intention to grant them any special right. I don't know which member state this was, they wouldn't tell me. But so it's not so obvious that it's going to be a nice situation for British citizens. And if we consider them third country nationals, what do you have is 27 different migration regimes, because each member state has its own immigration. And if they are considered third country nationals, you might, visas I don't think is going to be a problem, but you might see that the country in question might start asking how much they earn, impose minimum income requirement, or a minimum activity requirement, and this is especially bad for part-time workers who usually are women, or people who have taken periods of work who again tend to be women because of their caring roles. The right to equal treatment would depend entirely on national law. And again, this is not very nice, because you might find that from one day to the other, you are no longer entitled to certain welfare benefits, even if you were relying lawfully on those benefits before Brexit. And you would mature a right of permanent residency through the third country national long-term residency directive, so as a matter of EU law, but that does not apply to Denmark. And as I will show you and to Ireland, but Ireland is not a problem because they have a special status in Ireland, British citizens. But what you get under the long-term residency directive vis-à-vis Directive 2004/38 is actually not comparable. So even though there are a number of member states that have ensured or reassured their British citizens that they will be able to continue working there, up to the point of reaching these 5 years of permanent residency under the long-term residency directive, you have this problem that is a diversified legal environment, and that British citizens would not be protected in EU law. And this is, we might forget how important is EU law protection, also in terms of supremacy and direct effect. So what happens after 5 years? What you have is that if British citizens are considered to fall within the long-term residency directive, there are differences that I have tried to highlight between that and what is currently provided for by Directive 2004/38, which in my opinion should apply to former EU citizens. So the long-term residency directive requires prospective conditions in order to gain the permanent residency status, so that you have to demonstrate that you have, stable, regular resources for the future, as well as sickness insurance. We know that Directive 2004/38 is retrospective. So if you have lawfully resided pursuant to the directive, then you would get permanent, in theory you would get, but permanent residency. Crucially, Directive 2004/38 does protect part-time workers, because they are workers under EU law, and in theory, we know that the practice is very different, but in theory, you might have worked very few hours a week and still be entitled to permanent residency. And I'm not so sure if I've stressed enough the gender dimension of this. We actually did manage to put a question to the Commission about the gender dimension, even of the withdrawal agreement for the citizens, and they replied, "It's fine, it's fine, because we're not discriminating women." Yes, have I ever heard about indirect discrimination? Anyway, we did ask for a full impact assessment on gender issues, and they refused, kindly. Now, the other difference is that lawful residence, so under the long-term residency directive, you have to have resided for 5 years, obviously, before getting long-term residency. But what is lawful residency is assessed having regard to national law, so it will change from each and every member state, whereas as we know in Directive 2004/38 is assessed according to Directive 2004/38. So the regime is the same, and especially the general principles might apply. The long-term residency directive obviously leaves a much broader margin of discretion to the member states, also in the context of policy and security grounds, and the status can be withdrawn in a way that it cannot be withdrawn in relation to Directive 2004/38, where you can be expelled, but on very limited grounds. The other crucial, very crucial, is that you have a very limited right to equal treatment under the long-term residency directive, so that the member states can limit that equal treatment to the core benefits, to what they consider core benefits in their welfare system. We know in Directive 2004/38, you have a full right to equal treatment. Once you are permanent residents, you no longer have to establish anything. You don't have to establish economic activity or economic independence. You are simply treated as if you were almost a national of the country of residence. There is very limited right to move. And the reason why I really don't like this idea that people who have exercised their treaty rights become equal to a person who has never been a union citizen. I find it very difficult to accept that. And this is also a legal problem because, of course, if you are protected in some way by the treaty, then your protection is much stronger. And again, the the long-term residency directive does not apply to Denmark, so we have a problem there. The other problem, which I think is very serious is that if we treat the British citizens as third country nationals, then they cannot have preferential treatment. Because there are limits to how and this derive from the human rights and case law of the European Court of Human Rights, but there are limits to the way you can prefer, aliens. And so it is not clear to me, obviously, because also otherwise you might decide that certain aliens are better than others just on pure racial grounds, which is not ideal. But if the British citizens do come within the scope of the third country national long-term residency directive, then I think there is an argument to be made that they actually cannot be treated in a better way than all the other citizens, absent an agreement with the UK. So this is, if you have an agreement with the country from where you are getting citizens, you are allowed to treat them in a different way. But I think it would be very difficult to treat British citizens better. And surely in some member states it would become a big constitutional problem to do so. So, whether you think that British citizens should be treated as former citizens or whether they should be treated as third country nationals, anyway, we are in a mess if we don't have an agreement, because there are areas in which you need coordination. You need either an agreement at EU level, or you will need bilateral agreements, a number of bilateral agreements. And even when they are easy, they take time. They take time. There are lots of agreements. The biggest uncertainty, but this is true, unfortunately, also within the withdrawal agreement, is, of course, for vulnerable citizens, people who are in and out of work, and so on. But even for citizens who are in regular employment or were in regular employment, you have the problem of social security coordination, which I mentioned at the beginning. And this is not only for pensioners, but it will be also for, say, for instance, Italians who are in the UK, who are working here, and then, if they ever will be able to afford it, given what the pound is doing, might want to go back to Italy at a certain time. And now I'm a beneficiary of that. I can do it easily because of social security coordination in relation to my pension. And that needs a legal framework. Again, recognition of qualifications is a real problem, because without a deal, we might find that from one day to another, you simply cannot do what you were set to do. And self-employed, in my opinion, are particularly at risk, because if you don't have because self-employment, there is a real problem about bogus self-employment being used to avoid all the welfare provision and welfare contribution that comes with being employed. States are very, very careful in allowing non-EU nationals to be self-employed in their territory. And there is a real risk that if we have a no deal, and then these people have to demonstrate, so say that we have a no deal and that we are very generous. In this case, you say, okay, if you were self-employed before Brexit, I will allow you to continue. The problem is that if you don't have the withdrawal agreement that does protect the self-employed person in the type of evidence they have to provide and whether there is a minimum turnover and so on, that the states might just apply their normal rules, and those can be very strict. So minimum turnover, but also, lots of evidence of continuous activity. What happens if you have interrupted your activity, there was a downturn, or you were about to go bust or something like that. Again, cross-border service providers and cross-border workers, I was thinking yesterday, how do we protect them if we don't have a deal? Because most of, at least for what I was looking at the Italian, communique, because I haven't seen the legislation yet. They focus really on residency rights. But what if you reside in one country and you work in another country, and this is a right under EU law? What will happen then if you don't have the withdrawal agreement? Because they are protected under the withdrawal agreement. And again, we have this problem of the vulnerable citizens that will fall through the net. And this is a problem even with the withdrawal agreement. I mean, it is a problem. There are going to be citizens who are going to see their situation dramatically changed, even under the withdrawal agreement. But if we didn't have the withdrawal agreement, then you don't even have the duty of lighter evidence, decisions in favor of the citizen, now expulsion pending a review, and all of that. And so these citizens, from one day to the other, might find themselves totally vulnerable. There was a letter to the Guardian of a woman who decided to stop working to care for her disabled child. She's Polish, and her husband doesn't earn enough for them to fall within, the family reunification under British law. And even with the withdrawal agreement, she doesn't have, at this moment, after 25 years in the UK, she does not have a right to reside post-Brexit. So, it might seem it's not going to be many cases, maybe, but it's going to be dramatic, even under the withdrawal agreement. If we don't have an agreement, it's going to be even worse. And on this happy note, I conclude. Thank you very much.